On my channel, I talk a lot about revocable trust and how they offer benefits to almost all of my clients. But oftentimes when people hear about trust, they think about only the wealthy needing them, especially when you hear trust in the context of trust fund kids and the wealthy using trust to hide their offshore accounts. It can be easy to assume that trusts are just for the 1%, the ultra wealthy, but that's simply not the case. And that's just one of the many misconceptions that I hear about trust all the time that are preventing potential clients from coming to me and getting a trust that would greatly benefit their lives, both in their lifetime as well as their children's lifetime when they try to pass their assets down to their kids after they're gone. And so starting off with misconception number one, we've got the one I just touched on, which is that trusts are just for wealthy people. Now, some of this is subjective depending on how you define. The rule of thumb that I have for my clients is, generally speaking, if you own land of any amount, or if you own a business that is any size, you should be putting both of those things into a trust. One of the most shocking things that clients hear from me on a regular basis is that I would never own land in my own name. I would only put it into a revocable trust. Because as we've covered in other topics, trusts can buy land, they can sell land, and they can own land. And they can do that at the sole discretion of the trustee. And the trustee is almost always my client who owned the land before, and they're not trading any of the ownership rights that they had. They're just avoiding probate with their land. And not only are trusts not just for the wealthy, they're for folks trying to get cost efficiency. Trusts, again, are a probate avoidance tool. Probate can oftentimes be more expensive than the trust process, especially when you factor in inflation and other factors that make legal fees go up over time. Trusts are oftentimes a more cost-efficient measure than if you waited and got a probate attorney after you passed away. And so at the end of the day, the bottom line is this: if you own land or if you have a business in your own name, you should consider getting a revocable trust on those assets. You'll have the same level of control, but you'll be avoiding probate, and it's one of the few times in law where it's a win-win. Now, the most common response that I hear to this is the second misconception, which is if I put something into a trust, I no longer own it. Now, this is one of those statements where technically the statement is correct, but substantively the statement is incorrect. Because with a trust, the client becomes the trustee of the trust. And as the trustee of the trust, you get to manage the assets within the trust according to your sole and absolute discretion. That means if you want to sell the trust assets, or if you want to buy more trust assets, or if you want to dissolve the trust later on down the road, you have the full discretion to do so because you are the trustee. Not only is the client the trustee, they're almost always the sole beneficiary of the trust as well, meaning they get to collect all the benefits from the trust. If it's a home, you get to continue living in the home. If it's a farm, you get to continue keeping the profits from the farm. And if you sell any assets within the trust, you get to keep any of the proceeds from that trust sale. And so in a very simple sense, you haven't traded any of your ownership rights. You've simply purchased the right to avoid probate by using a revocable trust instead of leaving it in your own name. Adding a little bit more complexity to this is the third misconception, which is my land or my farm is already in an LLC and therefore I can't put it into a revocable trust. Now, there's two reasons why this statement is technically not true, and we'll walk through them in order, but the second one is the one I want you to focus on. The first reason is, yes, technically you could deed your land from an LLC to a revocable trust. There's no rules against that, but it's not something I would advise to do. And that is because the second option is more advisable. Now, that second option is, instead of deeding the land from the LLC to the trust, is to put the ownership of the LLC from yourself to the trust. Now, this is a little bit of a complex topic as to why we do this, but the essence is this. As the owner of the LLC, you have the right to do anything you want within that business so that it runs properly. But an LLC only offers liability protection, whereas a trust offers probate avoidance. A lot of my clients and potential clients who come into the office they ask what's better? Would I rather have the liability protection of the LLC or the probate avoidance of the trust? And the answer is you can really have both by taking this step, which is the land is still owned by the LLC, but the trust becomes the owner of the LLC. Now, in doing so, the client is the trustee of the trust, meaning they get to manage any assets of that trust and benefit from any of the benefits of the trust because they're also the beneficiaries. And that trust owns the LLC. So when that client passes away, they don't own the LLC, the trust owns the LLC, and so it can pass to their kids or whoever they want it to go to after they pass away. But we're not sacrificing the liability protections offered by an LLC because the land is still owned by the LLC, and so it's protected. And this is why farmers make some of my best clients, because they can avoid both probate and they can get the liability protections of an LLC because the land is a business use asset. Now, a little bit of a variation of misconception number 3 is misconception number 4, which is if my land is in a revocable trust, I don't need an LLC because the revocable trust gives me protection. And while it is true that a revocable trust keeps your land out of probate, it doesn't offer you any liability protection from a lawsuit. This is where the distinction between a revocable trust and an irrevocable trust comes into play. With an irrevocable trust, anytime you get sued personally in your own name, anything in that irrevocable trust is off limits to whoever's suing you. That's not the case with a revocable trust. Anytime you get sued for something you personally did, anything in a revocable trust that you're the beneficiary of can be accessed by a plaintiff. But there's one catch to this. If that land is already owned in an LLC, or if that business is already owned in an LLC, then that business is protected from your personal use lawsuits because of the LLC. And so going back to what I've said a couple times already, if you have the trust, that protects you from probate. And if you have the LLC, that protects your business from lawsuits. But if you have both, and you can, then you have both probate avoidance and liability protection. Misconception number 5 really relates back to one of the earlier misconceptions. Misconception number 5 is that if you put your land in a trust, you'll never be able to get it back out. In other words, you'll never be able to sell it if you want to sell it. If you need to liquidate it to pay for medical expenses, you won't be able to do that. If you want to give it to your kids, you'll never be able to do that. Now, again, this goes back to the distinction between a revocable trust and an irrevocable trust. If you put your land into an irrevocable trust, it's true for the most part that your land is stuck there, or at least it's very hard to get out of an irrevocable trust, which is why I recommend to my clients to use revocable trust, because revocable, it's in the name. You can revoke that trust at any point in time, take it back out, put it in your own name if you feel the need to do so. Now, again, I don't recommend that for most of my clients, but it is something that just gives them a little bit more peace of mind knowing they're not locking themselves into something that they don't inherently trust. Now, the second to last misconception is one that I see all the time, and it's one I completely understand. Misconception number 6 is that for every piece of land you own, you need a separate trust. Another variation of this misconception is that for every state that you own land in, you need a state-specific trust for that land, and neither one of these are true. In fact, for most of my clients, I only recommend the husband and wife getting one single revocable trust, even if they own land in multiple states, even if those pieces of land are in states that are nowhere near each other. I've had clients that have had land that is thousands of miles from where their next piece of land is, in many states over with different laws under it. The only distinction is if you own land in different states is you need to have an attorney that's licensed in that state to do a quitclaim deed from yourself to the trust in whatever state that trust was formed in. For the same reason, even if you move to another state, you can keep the same trust that you had that was in the state that you were originally in. Again, it's revocable. So if you ever feel the need to update it because of a new state law that you moved in, or a new family situation that you find yourself in, maybe you have grandchildren, then you can update the trust as needed. Not only is a revocable trust fully revocable, but it's also partially revocable. You can change any single term of it at any point in time during the initial trustee's life. And the reason clients are concerned about this is because they don't have to buy a trust every time they buy a piece of land. It's not a cost-efficient thing to do, and it's why we don't do it. And if you want one piece of land to go to one person and another piece of land to go to another person after you pass away, you simply put in the trust, parcel 1 goes to this person, parcel 2 goes to this other person. That fact doesn't change how many trusts you need. In fact, the only real situation I've ever seen where clients need multiple trusts is where you have a husband and a wife who were previously married with other kids. That's a topic for another video. The last misconception that we'll hit is misconception number 7, which is that if I put my land into a revocable trust, I'll lose my homestead exemption. Another variation of this is also that I'll lose a certain amount of ag conservation depending on what state programs you have. Essentially, the fear is that if you put your land into a revocable trust, you're going to lose some amount of property tax exemptions that you're utilizing now while the land is either in your own name or a business's. This is one that I'm a little cautious to wade into, but just know for the most part, I have yet to see this with any of my clients with any of the states that they're in, because states generally want to encourage you to put land into a trust so that it can stay out of their probate court systems that are usually already swamped with different cases. But again, as with all of this information, it's state by state specific, and I don't want to give very broad blanket statements. This is not formal legal advice, but it's the closest thing that I can give you to legal education and keeping it free without meeting with everybody in the country one-on-one. So I hope this has been helpful. If you want more videos about misconceptions about trust or any other aspect of law that I do, put a comment in the video. I'll add more as they come up and as I hear more from clients. And so I hope this has been helpful, and I hope you consider looking into revocable trust. If you're interested in information like this, please check out the other videos on my channel as well as the blog on my website where I post about these things routinely. And if you're interested in getting services from my law firm, Brown Law Office, check out my website in the description. You can shoot me a message on there and we'll get in contact with you as soon as we can.